Proposition 11 is funded primarily by the largest private ambulance company in California called American Medical Response, which has poured roughly $22 million into this proposition. It's primarily about labor law and employer liability for violations of labor law. The proposition sets out to do four things. First, Prop 11 would require EMTs and paramedics to stay on call during their whole shift, including during meal and rest breaks. Second, the proposition would eliminate employer liability for all labor violations, including pending lawsuits that occurred on or after October 25th, 2017. The proposition would require employers to provide additional employee training on a number of issues, including certain emergency incidents like active gunfire, acts of terrorism, and natural disasters. Finally, the law would require employers to provide employees certain mental health services. The idea is that EMTs and paramedics often experience traumatic events during work and have higher rates of PTSD. The proposition was in part prompted by a 2016 California Supreme Court decision called Augustus v. ABM Security Services. The case involved private security guards whose employer required that they keep their radios on during breaks. The court found that this requirement ran afoul of the California Labor Code and found for these workers. Private ambulance companies claim that this decision extends to them and that full compliance would increase their costs by millions of dollars per year, and that they would in turn pass on these costs to local government. The union representing 4,000 ambulance workers, United EMS Workers, agrees that there should be a fix to the Augustus decision, and in fact, they supported a portion of a bill in the California legislature which stated that ambulance employees could be required to monitor their communication devices during breaks and could be required to answer an emergency call. However, the union does not think that pending lawsuits against these private ambulance companies for violation of California labor codes should be thrown out. They believe that these companies should be held liable for labor violations that have already taken place. The San Francisco Chronicle editorial board has recommended that for this very reason, voters should vote no on Proposition 11. If you think, like the San Francisco Chronicle editorial board and the union, that these private ambulance companies should be held responsible for violations of labor law that took place before October 2017, then you should vote no on this proposition. If, on the other hand, you think there is too much at stake with regard to public safety, then you should vote yes.